Are you not going to recuse yourself?
No, I'm denying your motion. Anything else?
Well, hey, folks, they say that you can learn more about a person by watching them under pressure than in their utmost triumphant moments. Now, if that's true, then Vallow Daybell gave us a master's class in manipulation, courtroom posturing, and psychological projection during a recent pretrial hearing. She's facing charges in Arizona for conspiring to murder Brandon Boudreaux, her niece's ex-husband. Now, Daybell used this public stage to do what she does best, what she's done best for years: twist the narrative, play the victim, and paint herself as a persecuted heroine. Hey, welcome to Profiling Evil. I'm glad you're here. And before we dive into today's frustrating court drama, do me a quick favor. Tap that like button down below. Hit subscribe and make sure that you've turned on notifications so that you don't miss a single update when we drop new content. And hey, if you're part of the growing community that's following this bizarre case, share this video with your friends. And trust me, they're going to want to be in on this one. Now, Profiling Evil, I try to do things a little differently by going beyond the headlines, digging into criminal behavior, criminal mindsets, and the investigative strategies, showing some of the subtle red flags that often go unnoticed. So let's look at truth, insight, and accountability while we dig into today's story. It's a textbook case of manipulation, courtroom defiance, and psychological unraveling. Now, not surprisingly, Vallow Daybell tried to turn on her pretrial charm during a pretrial hearing, and she tried to turn this thing into a one-woman show when the judge started the hearing. Beresky, the judge, began by addressing a series of motions and administrative issues. Prosecutor Trina Kay was clear, composed, and methodical. Vallow was representing herself, and she gave her name plainly, Vallow Daybell. But it didn't take long for the facade of civility to begin to fracture. The judge immediately started referencing the state's intent to use other criminal acts by Vallow. He was citing Rule 404B and said this is kind of a common legal maneuver where the prosecution uses it to demonstrate things like premeditation or motive. Daybell remained calm, but like any master manipulator, I think she was just simply biding her time. 4 minutes later, Daybell started laying the victimhood stage out by claiming that the state of Arizona withheld vital information, and she challenged Judge Beresky directly, saying, quote, "Can I ask under what law or rule or statute that this motion was sealed?" Close quote. The judge has been, I think, incredibly patient with Vallow Daybell. He reminded her that the sensitive nature of the material required sealing it. Still, Daybell pressed harder, not because it negatively impacted her defense, but I believe it's because it gave her another chance to push the idea that she's a victim, that the system is against her. And perhaps the most revealing moment came when Daybell demanded that she not be required to wear restraints during the trial. She cherry-picked from a Maricopa County Sheriff's Office email a suggestion that they had recommended her freedom in court. Well, that wasn't the case at all, and the judge quickly corrected her, saying, quote, "Their minimum recommendation was that you wear the rack belt," close quote. Now remember, that's the belt that they could shock her with. And it was a classic moment. I think it's so good, I want to just replay it for you.
Then we have the defendant's motion for no restraints in trial dated May 6th. I don't know, in your motion, I don't know where you get the idea that the sheriff's office recommendation ever was that you have no restraints at all. Their minimum recommendation was that you wear a rack belt.
Well, I have it right here and I copied it verbatim.
Yeah,
Okay.
you said, what it said was my recommended minimum requirements as listed above, and those were to wear a rack belt.
It said, or the recommendation of MCSO was that they could have a unarmed detention officer and an armed deputy sheriff if I was to not have any restraints.
Right, but that wasn't their recommendation. I've received the defendant's motion. I've received non-party Maricopa County Sheriff Jerry Sheridan's response.
On the MCSO security justifications, my understanding is that was his recommendation.
Your Honor, Joseph V. Hill for the Sheriff's Office, if you have any questions.
Oh, okay. Well, I'll deny the motion from the defendant. The same conditions will be set that we had in the first trial, that being you wear the rack belt, no leg brace. There was one incident during the trial where you asked to take a break because a strap was hanging down behind your jacket. We did that. We rectified the situation. There's been no indication whatsoever that the jury noticed the rack belt or anything like that. So I think those conditions are appropriate and will remain for the second trial.
Your Honor, the jury was not polled to see if they noticed anything either. Was that correct?
Right. There was no request for that.
And even when confronted with facts, Lori clung to her own interpretation of what was going on. And this behavior mirrors what forensic psychologists call reactive defiance. It's kind of a hallmark of narcissistic and histrionic personalities. Now, Dr. Ramani, a clinical psychologist and expert in the narcissistic behavior area, a person who's appeared on Profiling Evil to discuss different kinds of behaviors, had this to say about that. She said, quote, "When a narcissist is corrected or denied something, they don't adapt, they retaliate, because anything less than total control would be perceived as a threat," close quote. Well, when requesting a secure meeting room to confer with her advisory council during lunch breaks in this upcoming trial, Lori again postured like a prisoner in a third world regime rather than a defendant in a high-profile murder case. Now, to his credit again, Judge Beresky accommodated the request, yet it wasn't enough for Lori Daybell. You see, for Daybell, each procedural win was simply the next stepping stone in a larger performance, building the image of this wrongly accused prophetess who's been silenced by a biased system. But then came the moment that I think broke the internet and possibly Lori's courtroom credibility. Lori dropped the bombshell. She said, quote, "I have to ask that you would recuse yourself from the obvious personal bias that you have against me," close quote. The judge just stared at her and said, "What bias do you mean?" And Lori doubled down. She said, quote, "A lot. Obviously, the personal bias that you're showing right now and that you've shown several times during the trial," close quote. And then Daybell spiraled into a tirade, claiming that every single one of her motions had been denied by the judge, everything over the past year and a half. Beresky, I think now a little bit angry, reminded her that just that morning he had granted her motion to meet with her legal team during court. I talked about it a moment ago. But Daybell, she didn't blink. Let's catch that exchange.
Your Honor,
Yes.
I have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right? I've over-accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that. All right? So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours. Okay?
That's the first motion that you've ever granted
Well,
in my behalf.
file motions that have a legal basis and I might grant them.
So you're saying none of my motions have had merit?
Not many, no.
And none of the motions that my first team, you denied every one of my first team's motions, you denied every one of my second team's motions, and now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied, every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit, okay?
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law, all right? They filed a motion to have you dressed out, not in jail clothes during hearings like this, okay? That was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied, 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 denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else?
Well, this interaction is a textbook infantile regression, a defense mechanism in which an adult under stress reverts to childlike behavior. Now, Dr. George Simon, a clinical psychologist, noted that when manipulators aren't getting their way, they'll often revert to tactics learned in childhood, tantrums, gaslighting, guilt trips, anything to reset the power dynamic in their favor. And I would suggest that Lori Daybell didn't need to revert back to childhood. She only needed to revert back to her continued use of manipulative strategies throughout her life. And make no mistake, this was a temper tantrum. Lori accused the court of systematic bias, of misrepresenting facts, of ignoring procedural law. And in her most telling line, she mocked the judge's rulings as mere rubber stamps, blurting out, quote, just denied, 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 close quote. Well, the judge patiently listened, and when she made her motion that he should recuse himself from the upcoming trial, Beresky responded with clinical finality. He said, quote, no, I'm denying your motion. Is there anything else? Question mark. Then, Lori Daybell tried to weaponize the witness list, stating that she wanted Melanie Gibb and Zulema Pastenas as possible potential witnesses. Now, this request came incredibly late in the game, and the prosecution objected, noting the inappropriate timeline. When the judge, who agreed with the prosecution, asked what relevant testimony those women would provide, Lori danced around it by questioning his response and stating, hey, it'll become apparent when they have to testify. Well, what kind of malarkey is that? Now, Daybell argued that she shouldn't have to reveal the nature of their testimony ahead of time, challenging the judge's insistence on pretrial disclosure. Well, once again, it wasn't about the rules. It was about rewriting the rules to suit her narrative. But she wasn't done complaining yet. She even objected to her name being included in the jury questionnaire, claiming that it invited bias through Googling. Judge Beresky explained, again quite calmly in my opinion, that omitting her name would make it harder to screen for prejudiced jurors and would risk burning the entire panel. But Lori wouldn't let it go. She said they're just going to Google it, ironically proving the need for screening. Well, I'm going to play that exchange, and I hope you catch that moment when the judge finally put her in her place, finally saying to her, are you going to respond or not? It was a great moment. Let's watch.
Your Honor, in light of the juror misconduct or the alleged juror misconduct, I have to object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
What personal information?
The state versus Lori Daybell.
What's the name of the case?
Yeah, but you don't put that on anyone else's questionnaire or one other person that's ever had that questionnaire ever put out with their name on it. They just don't do it.
Do it in every trial I've done.
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep? Okay. How do we screen for if people have heard about you if we don't include your name? Do you have a response to that?
I'm just saying, you gave them the name, and they're just going to Google it.
They're instructed not to Google it, all right? And if you'll recall, when we had all the jurors come in person, one of the first questions I asked them in the afternoon was, who has looked up this case since you filled out the questionnaire? And we had 2 or 3 people raise their hand, and those people were excused. So I have to include your name to screen out for the people that know about your case. And we released about 100 jurors last time because of their answers to that. If we don't include your name, that's 100 extra jurors we have to go through in person and ask if they know you. And in fact, that increases the risk of tainting the rest of the jury pool if we have someone stand up and say, yeah, I know about her case in Idaho where blah, 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 in front of the rest of the jurors. That'll burn the whole panel. We'll have to start over. So I'm going to include your name in the questionnaire. I don't think there was any other personal information or background information about you in that questionnaire other than your name. So was there any other issues you had with the questionnaire?
No, Your Honor.
Well, in my opinion, even though Lori Daybell hasn't been officially diagnosed in open court, her behavior reflects traits of narcissism, personality disorders of narcissistic personality. Now, that inflated sense of importance, the need for admiration, and the lack of empathy all show signs of that disorder and another called histrionic personality, where an individual actually is excessively emotional. They seek attention and they display a lot of drama in their presentations. Lori Daybell is defiant, argumentative, and seems to be vindictive toward any authority but her own. Now, this hearing wasn't just about legal wrangling. It was a theater for Lori Daybell. Her performance as a persecuted prophet in chains was deliberate and strategic. She's not just defending herself legally, she's trying to preserve her mythos, especially to any remaining followers who still might believe that she's spiritually above the law. Or more importantly, in my opinion, to those people that she plans on proselytizing to in prison, the ones that she wants to join her cult. But it didn't work in Beresky's courtroom. That's a place that's governed by facts and procedure. There, delusion doesn't hold up. And as we get closer to trial, one thing is going to be abundantly clear. Lori Daybell isn't just on trial for her alleged crimes. She's on trial for her manipulation of truth, of faith, and of every person who once stood too close to her orbit. So that's it for today, folks. Drop your comments down below. I'd really love to hear your take on the chaos happening in the courtroom. Do you think Lori Daybell's outburst was strategy or just another glimpse into her unraveling psyche? And don't be shy about jumping into the conversation with other people. But like I said before, just please keep it constructive, keep it kind, and keep it respectful. And thanks for watching Profiling Evil. Your support means the world to me, so be sure to follow along on Facebook, Instagram, YouTube, and Twitter. And that way you'll get all our latest updates, the behind-the-scenes content, and expert insights. And if you like true crime on the go, go check out Profiling Evil's audio podcasts on your favorite podcast platform. And if you're hungry for more information, go to profilingevil.com where you can check out our story maps, cold case information, and all kinds of stuff. Sign up for the Bolo while you're there. That's our digital newsletter. And if you love true crime books, check out my investigative memoir, Deceived. That's where I take you inside one of the most disturbing cults in American history, the Zion Society. And you know what? We're going to be opening a brand new Children's Justice Center next week. And the proceeds from purchasing Deceived have been going toward that new center. I'm showing you some video right now of what that center looks like. And I'm so excited because survivors, some of those 32 kids that were rescued 35 years ago, are going to be on hand for the ribbon cutting, and they're going to be talking to the media. I'll try to share some of that. And you might also enjoy my book, She Knew No Fear, the story of my great-great-grandmother's 1891 murder, and how I solved that murder a century later. Both of those books are available at profilingevil.com. If you live in the United States, I'll personalize them and I'll send them to you for free. But if you're overseas, you can get them anywhere throughout the world on Amazon. So watch for my new book that'll be coming out in the next 2 months. I think you're going to really want that one. I'm really excited about it. Hey, thanks for listening. And thanks for dropping your thoughts in the chat down below. We'll see you soon at the next crime scene.